Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. Ann and I have returned. Ann Lipton is, of course, a law professor at the University of Colorado who teaches and researches securities and business law. She holds up and presides over the legal end of our podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Great. I'm going to remind you, why don't you talk about our mailbox? You want to do that?
Sure. So we have an email address, which you can email us and you can ask questions or ask us to talk about particular topics. We are at shareholderprimacy at freefloat, one word, .llc.
Excellent. Well, we talked about covering a couple of interesting subjects. One is based on some quite recent news on a case that's been going on for a while. And another one reflects something that I had thought about. I'm not the only one who thought about it, but others have. Many, many years ago, but came up again and sort of remains timely. So the latter one, which we'll talk about a little later, pertains to whether corporations are people. Mm-hmm. And we can explore that odd formulation a little later. But first, though, we were going to look at a particularly juicy bit of M&A litigation involving Activision and Microsoft's acquisition thereof. So why not begin with that, may we?
Of course.
All right. So the proximate news was Delaware Chancery Court and our old fave, Chancellor McCormick, allowing a shareholder, is it a class action, shareholder class action? So it's not derivative. It's a class action lawsuit to proceed against the directors of the formerly independent and public, but now owned by Microsoft, Activision, which of course is the video game company, which, what are some of their games? Do you happen to know?
Oh, for God's sake,
I don't know.
I'm not a gamer.
I don't even know. Anyway, they have some big games.
I'm sure they do.
Yes. Microsoft wouldn't have paid all that money for them if they didn't. And they merged, and the merger closed in 2023, and then the lawsuits started flying, right? Yeah. So Microsoft bought them. So what's notable for now about this case?
Well, here's why this stands out for me. So we have talked several times throughout this year about how there was essentially a revolt among a bunch of powerful companies in Delaware and backers like private equity firms complaining that Delaware was too litigious, that it was creating too much litigation risk. And as a result, as we've said, Delaware essentially rewrote their laws to make it very easy for boards and controlling shareholders to insulate themselves from any kind of shareholder challenge. And yet, Chancellor McCormick just held that a merger challenge could proceed. And technically, this challenge was brought under the old law, the new limits don't apply, but it's not obvious that they would have made a difference. Her basis for allowing the case to proceed might not be affected by the new law. So the reason this really surprises me is leaving aside everything else, this was kind of an uphill challenge to begin with, even leaving aside
uphill challenge for the plaintiffs.
For the plaintiffs.
Yes, okay.
But even aside from that, when I think the Delaware legislature kind of demonstrated such hostility to shareholder litigation that I sort of expected some Delaware judges might kind of get the message that they should be more skeptical of shareholder claims. And here's McCormick coming out guns blazing, saying no, it was doing what I'm doing.
And it was guns blazing. She wrote like an 80-plus page.
Well, for Delaware, that's nothing.
Opinion. Okay, for me, who I looked at, for me, who's not the lawyer here, it was a lot to kind of wade through.
But there
was some I'm not going to say incendiary, but there were some fairly big words going on.
And so I want to be really clear. She's not like defying the legislature. She's not. The new law wasn't an issue here. But she's definitely indicating that even if they change the law, they can't like bully her into changing how she thinks about these kinds of claims. She's going to think about them the way she thinks about them.
All right,
so that's
cool.
Why I just
so the significance here, in addition to being significant for Activision and Microsoft shareholders and so forth in some fun ways, because some of the facts on the ground are also pretty notable. The significance here has to do with the and we'll return to this, the importance of the statutory changes
Yeah,
and how
like
they
whether
would have affected
yeah,
this huge case had it been filed this past spring rather than
yeah,
2 springs ago.
yeah.
All right, cool. So what are some what are the claims here? What's being alleged?
Yeah, so the basic claim is that the Activision board undersold the company, that the price was too low. They didn't get enough value for shareholders.
It
So the
happens
idea,
I think about that all the time, by the way, in
I'm
case
sure
you're
you do.
wondering. This is a big
Well,
problem.
yeah, so several years ago, Activision was a standalone company, and then there
Right.
was this big sexual harassment scandal. It was like the middle of Me Too, and there were all of these allegations that its CEO, Bobby Kotick, knew, and he covered it
Yes.
up. And there were employee protests, and the stock price tanked, and there were regulators involved investigating. So there was a real chance that Kotick was going to be ousted for cause, which would mean he'd forfeit a lot of his pay. And at that moment, with Activision's stock price, shall we say, temporarily in distress,
Right.
Microsoft swooped in and offered to acquire the company. And the fundamental allegation in the case is that the board rushed through this deal with Microsoft in order to protect Kotick and avoid dealing with the sexual harassment scandal, but they didn't really get the maximum amount they could have gotten for shareholders. So
So the idea was that Kotek either alone or persuaded the board. The board was trying to
with the
protect
board, yeah,
Kotek. I mean,
exactly.
there
It
was
wasn't just
some
Kotick.
balance there. Yeah, right.
Yeah,
Exactly. Okay.
Kota couldn't have done it himself, but the facts in the opinion are pretty damning. And to be clear, I just want to be clear, it's only a complaint. We don't know what discovery will show. But based on the allegations, plaintiff's side of the story, according to the complaint, the board, first of all, let Kotick handle the whole process. Even though they knew that he was conflicted. And he pretty much got ahead of the board on several occasions and started negotiating and making promises before the board got involved. The board suddenly revised its projections of the future downward for no good reason, which apparently made
Oh,
the Microsoft offer look more attractive. They spurned alternative acquirers without really engaging them because they were trying to like rush through this deal more quickly. And the ultimate merger agreement explicitly protected Kotick's job and his salary and indemnified him from future claims. And then, like, the merger was dragging on because there was a lot of antitrust risk to the point where it actually reached the outside date where Activision could have walked away. And at that point, Activision, its stock price had recovered, its new games had really taken off. So it was in a better position like, to have told Microsoft either up the deal price or we'll walk away, or looked to
yeah.
see if other acquirers would have paid more. But the board didn't. It just sort of rushed in to extend the outside date. So these facts put together were the basis essentially for the plaintiff's claims.
Got it.
And yeah.
So there wasn't a single thing, but there was a number of facts that we know of so far, and the facts are just based on, not discovery, but just public documents or whatever the
Right. And
plaintiffs
this
were
is
able
where
to
we
get
get to,
from books and records demand. Yeah, right.
yes, exactly, which is the twist of whether the new law would have affected anything. But right, so the interesting thing here is that this is definitely a story of a sloppy board. But the plaintiffs couldn't succeed on their claims just with a sloppy board. They actually, in order to be able to advance their claims, they needed to show disloyalty, like an actual disloyal board that was consciously not acting in the best interest of shareholders.
And more loyal to the CEO essentially than to
Exactly.
the shareholders.
Than to the
Okay, go
shareholders.
ahead.
And
Yeah,
here's the thing about that. The way you normally show disloyalty, the easy case for disloyalty, is a conflict, like an actual conflict of interest, like a financial conflict. And here
right.
we absolutely had that with Kotick, because he was saving his job and he saved his change of control benefits, but there was no conflict for the rest of the board. In fact, McCormick did not even find that the other board members were not independent of Kotick. Like, she never found that they were so close as to compromise their independence. Instead, she concluded that based on these facts, they were so egregious that they suggested that the board acted in bad faith, that they were actually just acting in bad faith. They just, even though they weren't like not independent of Kotick in the traditional test for independence, that they were just more interested in protecting him and perhaps, I think, just not having to deal with the sexual harassment scandal and
Sure.
figure out what to do about it. And they just wanted to plow ahead and get this off their hands. And also, I mean, there was a shareholder vote. And normally, as we've said several times, shareholder votes will
Oh,
cleanse
they
any
cleanse,
problems
right? They
so that you
wash
don't.
it completely. They disinfect
Exactly.
it.
But there has to have been full disclosure. And she held that the shareholders weren't told about the role that sexual harassment was playing in the board's decision making. So, therefore, there wasn't full disclosure. And she refused to dismiss the claims. And the case goes forward on the theory that the board acted with bad faith. Now,
All right.
one thing about this case,
Go ahead.
normally, if a board isn't conflicted, we've said several times, if a board acts and they are not conflicted, normally their decisions are extraordinarily deferred to by courts. They get the
Right.
business
Yeah, it's
judgment rule
business
defense.
judgment rule governs, right?
But there's an exception if it's a sale of the company. When the company is being sold, then courts look a little bit more closely at the board's process. It's sort of an intermediate standard. It's not as closely as they look when there's an actual conflict, but it's more carefully than business judgment deference. And it was because of that closer look that she was able to conclude that plaintiffs had shown bad faith. But it's still striking that she went that far, especially given the current atmospherics in Delaware.
Oh,
So
atmospherics related to the sort of the political
whole
environment.
the political environment, and essentially the legislature saying as clearly as possible, courts, you should dismiss these cases.
So she held essentially that there was I mean, again, this wasn't a case. This hasn't been decided on the merits. She's basically just letting the
that the
case
complaint could go
proceed,
forward.
which we'll talk about in a minute. So she essentially held then that there was evidence of this bad faith,
Right.
and because of the failure to disclose the sexual harassment stuff, the case
partly
can go
the failure
forward,
to disclose the sexual harassment case. Well, that's why the shareholder vote didn't cleanse anything. But the bad faith was really more like just the board's lackadaisical approach. Well, not lackadaisical. They rushed it through without fully, exploring the alternatives, without apparently changing their projections to benefit Kotick.
Extended the drop dead date.
Outside date.
See, that's usually what an activist is is kind of waiting for. Yeah. There's plenty of situations where you sort of see this deal and you don't exactly know, what went on and so forth, but you sort of maybe sometimes you kind of cross your fingers and hope that something delays it and that they can, and then the board came in and said, no, you get another, 3 months, whatever number of months.
Yeah, because they knew they were going to have antitrust problems and they were still litigating over it. And here's another thing, though. This case actually proceeded in stages. In an earlier stage, the plaintiffs alleged that the board, it wasn't simply that they acted in bad faith. The plaintiffs actually pointed out that the board violated Delaware law because they were in such a rush to approve the merger agreement that it wasn't complete when they approved it. They approved essentially an incomplete deal.
There were blanks. It was like
the price was blank. They were blanks.
Oh wow!
And they approved this deal. And Delaware statute requires boards approve merger agreements. So in an earlier stage of the case, she allowed the claims to proceed based on this deal was never properly approved. And this upset the legislature so much that they immediately changed the law to say that now boards are allowed to approve like substantially complete deals. They don't have to be all the way complete. So even though they did that, again, she would like this is now the legislature specifically responding to her decision in an earlier stage of this case to overrule her with a statute, and she still is allowing the claims to proceed. She persists.
She persists. Okay, so here's the question, which gets us back to the theme here, which is if the case had been brought this past spring, after I can't remember SB 22, is that what it was?
SB 21,
whatever 21 was the law of the land or the land in Delaware. What do we think might have changed as a consequence?
Okay, so here's the thing: the new statute deals with conflicted deals, how to cleanse conflicted transactions. This is not that case because other than Kotick, this wasn't a conflicted transaction.
There was no conflicts. He wasn't a controller.
Right, exactly. So he was conflicted, but the rest of the board had to agree, and she did not find they weren't independent. She just found they just acted badly.
And he probably recused from the vote or something.
Oh, I don't think she did because he wasn't conflicted in the traditional sense. He just was
whatever.
more like,
it doesn't
I want to
matter.
keep Anyway, so he ran the whole negotiation process. So this actually, all the conflict cleansing procedures that were added to Delaware law, none of them actually have anything to do with this case. The
Okay.
only thing that I think the new law maybe might have affected is this. As you said, the way the plaintiffs were able to make all these allegations was based on public documents and a 220 request. They made a 220 request.
Yeah,
Now,
220 is a books and records demand.
request.
Right.
Now,
Right.
I don't know what they got, but I think we can infer that they got some things that helped them with their allegations. And one of the things that Delaware changed was it changed the standards for 220 requests, and in particular made it harder to get certain kinds of documents, especially informal materials. So it's possible that if brought today, the reason it might have been more of a battle wouldn't have been because of conflict cleansing, but because they might not have been able to get the same information that they ultimately were able to get. But I don't know for sure because I don't know exactly what they got out of their earlier 220 requests.
I would expect, it's funny because I did not read, again, I mentioned I kind of skimmed the Chancellor McCormick's ruling here, but I didn't look at the footnotes. I didn't look at all the evidence. I just kind of was trying to get the gist of it. And I would imagine a resourceful, assistant law professor, somebody I don't know who, could go through it and figure out what facts are in the.
I mean, like, well,
that's the basis for that, and figure out what might have not been available.
Because the complaint has blacked out parts. That was probably what they got.
I didn't read. Okay, so you read the complaint. I didn't read the complaint.
Well, I didn't read it. I flipped through it, and you can tell where they're using confidential information.
Sure.
And a bit like a lot of judges, she writes the opinion. I don't think she cared what was blacked out, whether it was confidential. This happens all the time, by the way. So. So you might be able to figure, but I don't know if they only got formal board materials, then they could have still gotten that under the new statute. But if they got anything informal,
right? If there was like some emails, if there was correspondence,
that would be harder. Now I know Activision fought the 220 request to begin with, and then after they filed a complaint, they finally caved. So anyway, that's the only way that I can obviously see the new law mattering.
Oh, interesting. So all right. So where are we? So this case is now going to proceed.
It's going to proceed. It goes to
and
discovery. It goes to trial unless it's settled.
Okay.
Which
okay.
it
and
will
so
settle.
That's your guess.
That's like. I mean, usually these things do. That would be my guess. But
right.
maybe
Mike,
not. Especially if Activision thinks that the Delaware Supreme Court is likely to be more sympathetic.
Well, no, it's not Activision making the decisions anymore. It's Microsoft.
Right? Yeah, yeah. Well,
Microsoft may not want to.
Well, their directors are it's not even Microsoft. Microsoft's not a defendant; it's the directors.
No, yeah, but Microsoft's funding this, and it's their reputation. And
yeah, because they're indemnified. So. They indemnify the directors.
All right, so let's stay tuned. We'll sort of see what kind of settlement gets announced in the next year. I guess. Is that right?
Yeah, I would expect, but maybe not. Who knows? Maybe we'll get a fun trial.
Cool. Oh, that'd be interesting. Let's see. We haven't seen one of those in a little bit. So, all right, great. All right, let's pause here, and then we can return to talk about corporate personhood here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin, and we're going to look at the question of whether corporations are people.
Yes, which sounds on its surface to be kind of weird, but let me tell you, because I've been meaning to ask you about this one for many months now.
Yes.
Now that I have a law professor in my directory, and it began back in 2012, a very different time in everyone's lives.
Yes.
And a little bit of the background is that at the time, we both have our kind of blogs. I don't know if it's a blog. You write a blog.
Yeah.
At Business Law Professors blog.
With other business law professors.
Right, there's other business
once
law
a week,
professors.
unless I get really excited about something, and then I post more than once.
And it's the noun is it's a blog. Well, I have the Substack that I write, which I still call a little bit of a blog. Well, before that, I had a blog, and then it was sort of just an email thing from about 2010 to 2016, and then I put it down for a while and picked it back up a few years ago. And so this dates back to a blog post I wrote in 2012 in that earlier time. And I have been reposting some of the old stuff on the new Substack periodically. So I reposted this one, and the title was Corporations Are People. People. And I made an obscure reference to a couple of bits of cultural artifact, which I can refer to a little before. One of them was the movie Soylent Green.
Yes.
It's people. Soylent Green is made out of people. Listen to me, Hatcher. You gotta tell them Soylent Green is people!
Or the other cultural reference was to the old, it was started as a record, Free to Be You and Me, with Marlo Thomas, where she talked about parents are people.
Yes.
Mommies are people.
Daddies are people.
People with children.
People with children. When mommies were little, they used to be boys.
Like some of you. But then they grew.
So
And now mommies are
at the time, Mitt Romney was the Republican presidential candidate, and he was at a campaign stop in Iowa, and he was getting heckled.
To be able to balance our budget and not spend more than we take in, we have to make sure that the promises we make in Social Security, Medicaid, and Medicare are promises we can keep. And there are various ways of doing that. One is we could raise taxes on people. That's not the way. Corporations are people, my friend. We can raise taxes on. Of course they are. Everything corporations earn ultimately goes to people.
So after that, and I found that interesting. At the time, I was very naive about what that stuff meant. And so I kind of thought about it a little bit. And then after that, shortly after that, Jack Welch, who was he was at the time he'd retired as CEO of General Electric. And, he was very famous. He's since his reputation has since taken a hit.
Yeah.
If you want to see what
Yes,
happened to GE.
yes.
Well, he wrote a column in a fairly weird column in the Wall Street Journal a few months later, basically asserting the same thing and saying, no, corporations are people. And it wasn't quite clear what was going on. So I then wrote a blog post that was fairly critical and saying, what could Mitt Romney or maybe Jack and Susie Welch have possibly meant? They couldn't have meant that a corporation's like a human being, okay? That and so what I was able to find out, and this is where I'm really eager for some of your thoughts, is that legal scholars, of which I would include you in that august group, call a corporation, the word I found was a legal fiction.
Yeah.
An artificial entity that was sort of created for like a very specific, and this appeals to me, a specific economic purpose. Okay. And so, a corporation basically as a legal structure, is basically allows multiple people or possibly other corporations or whatever, investors, to syndicate your money and to kind of spread out the investment and to limit your personal liability for its failure and so forth. So what I learned after that was that, corporations in fact do have some of the same rights and obligations, I guess, as
Yes.
real human people. So, a corporation can enter into a contract.
Yep.
And it can collect income, and it pays taxes.
And it owns property, and it can
owns
be sued
property.
and be sued.
Right. Okay. However, a corporation can't marry another person, and a corporation can't have custody over a minor
But
child type person.
But it does have First Amendment rights.
Well, now it
has free
does.
speech.
And-
It
and-
does. It has free speech rights. It has religious rights.
Right. Oh, religious rights? How so? That's interesting.
By poor theorizing of the Supreme Court.
Okay. So anyway, so what I kind of wondered was whether kind of Mitt Romney at the time and Jack had sort of misunderstood, Jack Welch had sort of misunderstood some of these legal rights and said that and what they really meant is not that corporations are people. That's like absurd. But what they may have meant was that they have some of the same rights and obligations as people, which we just talked about. Is that seem
Well, legally,
plausible?
legally, corporations are persons. They are legal persons in the sense we are called
Okay.
they are artificial persons as
Yes.
distinguished from natural persons.
Like human
Legal
flesh
per-
and blood people.
Yeah,
Yes,
so like in
right.
legal parlance, that is how you would distinguish them. You would distinguish them artificial persons from natural persons. And they have the legal rights that are associated with personhood up to a point. They can sue and be
Right.
sued, they can own property, they have free speech rights. What they don't have, I believe, are Fifth Amendment rights. I mean, it's just, they don't have
Okay.
all the same rights as people.
Right.
But from a legal perspective, yes, they are considered legal persons. Now, separately, as a matter of corporate theory, there are essentially three views of what a corporation is.
This is really what I'm trying to ask you. I think that
Yeah.
you're getting to what I want to talk about. Okay, go ahead.
So one view of a corporation is what's known as concession theory, that they are essentially a state creation. And
Yes.
the state, and they have the privileges that the state gives them. Another
And the
view-
state could be in government.
Yes,
It's
government.
state law or federal or whatever.
Yeah,
though most
exactly.
corporations exist under state
under state
law
law.
in
There
the
are
US.
some
Okay.
federally chartered corporations.
Right.
And then, so that's one view, that's concession view. Another view is the contractual theory of the corporation, which is essentially that the corporation is a structure for the multiple different contracting parties. Shareholders are one contracting party, lenders are another contracting party, employees are another
Vendors,
contracting party.
right,
Right,
yeah.
exactly. And it sort of is sort of nexus of
Contracts, yes.
for all of these different parties to do business with each other. And the third view,
and that's contractarian. I think I've
that's a
seen that called.
contractarian view.
Okay.
And then the third view is closest to person. It's called the real entity theory, that the corporation is something greater than the sum of its parts. It's sort of that it functions together as a whole, and should be treated as a whole. I mean, not a human, but as a whole
Right.
entity
Sort of a thing
that has will, if not thought.
Right. Okay. All right. So there's these three kind of, I've seen a little bit of this kind of guide some of the legal
They guide
arguments
legal
and so
arguments.
forth.
I mean, my view
Yeah, right.
is that it's not a question of one or the other. It's like that duck rabbit picture or the old lady young lady picture.
Some of the optical illusions.
Yeah, exactly. It's why you can't answer the question until you understand why you're asking it. And
I'm
it's different
glad
for
you.
different purposes.
I'm glad you brought that up that way, because it's always, there's among the investor class, we always talk about investors or activists as owners.
Mm-hmm.
Okay, we want to behave like owners. We want to put, portfolio managers in the board because then you have an owner's perspective.
Right.
We're exercising our ownership rights. But this kind of gives some more interesting, if a little theoretical
because-
context for who the owners are and what exactly they own.
Exactly, because
Yeah.
one view is that, essentially if you have the residual claim, what shareholders claim, you are the owners. And in bankruptcy, then the lenders would be owners because they have the residual claim. But
Right.
I mean, again, I for me, I think ownership, you have to unpack why you're asking. I mean, the first thing a law student learns in property is that there's no such thing as owning a thing, because there are usually limits on what you can do with it. Like you might own land, but maybe somebody else has an easement.
Okay.
You might own land, but that doesn't mean you can do anything you want on your property. You can't do things that will create a nuisance to other people. So ownership is really just a bundle of rights with respect to any particular thing, and you have some of those rights and you don't have others. And it's
Right.
the same thing with shareholders. Like we call shareholders the owners, and sometimes people like to get cute and call them share owners. But
Yes,
the
right.
reality is that what they have is a certain bundle of economic and governance rights. And whether you put the label own on that or not isn't really the point. It's you have a certain bundle of economic and governance rights, which may or may not have certain implications about
Interesting.
your moral claims or anything else.
Okay. So this, I think this informs much better this assertion that corporations are people than what at the time,
Yeah.
14 whatever years ago.
I remember
And
him saying
today
it, but I
when
honestly don't even remember why it came up.
because I went and reviewed the whole thing again when I reposted this thing, which was just a few months ago on the Substack, and then in preparation for talking about it today. I think the context was a tax argument related to the 2012 political campaign. And he said, yeah, corporations pay taxes because corporations are people
like
or
they
something.
Are treated like people.
True.
They pay taxes.
Right,
they
exactly.
pay taxes distinctly from their shareholders, which is not
Right.
true of LLCs and partnerships.
Right. But in particular, the Wall Street Journal op-ed from the Welches was especially silly. Because they started getting into all sorts of weirdness about how corporations, have people in them, and then they have feelings. It was really weird. So anyway, so it's worth a look if you next time it's some part of the curriculum or the syllabus when you're talking about corporate personhood, assign the Wall Street Journal column. It's a little fun actually if you want to know. So anyway, so that's kind of what this is great. So this is kind of what I wanted to bring up was this whole idea that of how this corporate personhood idea concept was sort of probably a little misunderstood. Yeah. But nonetheless is quite relevant and actually kind of useful. So all right, enough about my rehashing old posts. I think for now, so we can probably move on to some new stuff, which we will do sometime soon. So we can wrap up and return next week. This is Shareholder Primacy, hosted by Ian Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is professor of law on the Lawrence W. Demuth Chair of Business Law at the University of Colorado Law School. You can find me, Mike, at theactivistinvestor.com and Ann at law.colorado.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening, and we'll talk again soon.